For many non-citizens living in the United States, the Employment Authorization Document, commonly known as the EAD, is the foundation of lawful employment. It is what allows people to work, support their families, and remain compliant while their broader immigration cases are pending. Spouses of H1B holders, asylum seekers, refugees, individuals with temporary protected status, and many adjustment of status applicants all rely on this document. Until recently, many of these work permits were issued with validity periods of up to 5 years. In addition, workers often benefited from automatic extensions if they filed a renewal on time, allowing them to continue working while USCIS processed the application. That framework has now changed. According to updated policy guidance from USCIS, the maximum validity period for many employment authorization documents has been significantly reduced. If your EAD application was pending as of early December 2025 or filed after that date, researstend in det dagsro och spekonsaler för den or dafsterdati goredekting, but a work permit is now generally being issued for up to 18 months rather than the multi-year periods many workers were used to. This change applies to both initial and renewal EADs across several major categories, including asylum applicants, refugees, individuals granted withholding of removal, and, many people with pending green card applications. The shift is not selective or rare. It affects a large portion of the work-authorized immigrant population. In practical terms, this means work permits will expire much sooner than they did in the past. Workers must now track expiration dates more closely, plan renewals earlier, and prepare for a system that requires more frequent interaction with USCIS. The margin for error has narrowed. At the same time, another critical safeguard has been weakened. For years, many workers relied on automatic extensions while a renewal was pending. That extension acted as a bridge, preventing job loss during long processing delays. Under the policy environment now in effect in January 2026, automatic extensions are no longer widely available for most EAD categories. This is one of the most consequential changes. If your existing work permit expires while your renewal is still under review, you may no longer be authorized to continue working, even if you filed on time and followed all instructions. For many households, this creates a real risk of employment gaps, income disruption, and uncertainty that did not exist before. This policy shift has already led to legal challenges, particularly from families where spouses depend on EADs to maintain dual incomes. Lawsuits have argued that ending automatic extensions undermines financial stability and lawful employment. However, as of January 2026, these rules remain in force, and workers must plan under the assumption that extensions are no longer guaranteed. These changes are not happening in isolation. They're actually part of a broader tightening of immigration procedures that began in late 2025 and continues into the new year. Federal agencies have introduced expanded security screening priorities and administrative updates that affect how immigration benefits are reviewed. In some cases, this includes increased scrutiny, additional vetting, and more in-person review requirements. Another major development intersecting with work authorization is the evolving approach to employment-based visas, particularly the H1B program. Toward the end of 2025, the U.S. government introduced changes to the H1B selection process, moving away from a purely random lottery and toward a system that prioritizes higher skilled and higher pay positions. While this rule was announced earlier, it remains fully effective in January 2026 and continues to reshape how employers compete for limited visa slots. When combined, these employment visa reforms and EAD rule changes create a more complex work authorization environment. Professionals and their families are now navigating shorter work permits alongside evolving employment-based visa standards. Careful planning is no longer optional, it is essential. At the same time, broader enforcement and screening policies are reshaping how work authorization functions globally. The State Department and federal agencies have implemented expanded vetting and entry limitations for nationals of certain countries. These measures can directly affect employment authorization when applicants are abroad, renewing status, or attending consular interviews. Many of these security-oriented changes became effective at the start of January 2026. The practical impact of these policies is often felt in processing times. Enhanced screening and additional review layers can slow adjudications even for routine work permit renewals. For workers, this increases uncertainty for employers. It complicates workforce planning and compliance. Despite the tightening overall environment, there have been limited targeted adjustments providing relief in specific areas, such as procedural changes affecting certain religious worker visas. However, these narrower updates do not offset the broader structural shift affecting most EAD holders. So, what does all of this mean for workers and families right now? So, it means earlier preparation is absolutely critical. Renewal applications really need to be filed as soon as eligibility opens up. Expiration dates should be monitored closely, without exception. Employers and employees both have to communicate clearly, and not just assume that pending applications automatically protect work authorization. And, most importantly, it means understanding that the rules many relied on just a few years ago, well, they no longer apply. January 2026 marks a real transition away from long-term work authorization stability and toward a system that's built on shorter validity periods, frequent renewals, and honestly, much stricter oversight. Work authorization is still available, and employment is still possible, but the responsibility to maintain compliance has really increased, and the consequences of delay or misunderstanding are now much higher. For immigrants and their families, awareness and preparation are now just as important as eligibility itself. That's all we have for this bulletin.